Welcome to you all for joining us today to talk about maximising your intellectual property that you as business owners and those that work within businesses are creating on a daily basis. And we're going to talk about the really exciting stuff of intellectual property. So the tax, the legal, and some of the economic strategies that we as a group will help you navigate to do exactly what we say on the tin, which is to maximise your intellectual property. So who are we? So we're from 3 different firms, because in order to help our clients around the world with intellectual property matters, we find it's best to use the best. These are us. My name, I'm Tom Adcock. I'm a tax partner here at Gravita. Gravita, all singing, all dancing UK accountancy and advisory firm based in London, the Southwest, and Oxford as well. I help advise clients all over the world how to deal with UK and international tax matters. And we've got a large team here that can help you and anybody else with anything that has the word tax in it. But we also do audit, accounts, and all the other advisory functionality you would expect from an accountancy firm. I'm joined today by David Holt. He's a partner at Clarkson. David, do you want to say a little bit about yourself?
Yeah, nice to meet everyone. So I'm a partner at Clarkson. I deal principally with non-contentious or transactional IP matters. I deal with a lot of global portfolios, across from life sciences into advanced industrial chemistry. Clarkson is a leading European IP firm. We operate out of the UK, Scandinavia. We have some offices in Sweden, Denmark. So withholding Europe. We work alongside other experts in tax matters, competition, and regulatory. So, such as Gravita, we help our clients engineer portfolios of IP and commercialize those. So, with that, I'll hand over to my colleague Esmé, who I work with regularly, who has a different perspective on IP.
Hi everyone, and thanks Dave. My name is Esmé Swindells. I'm a partner and qualified patent attorney at Clarkson. I work on the side of IP, of gaining those rights, and as my title suggests, I work specifically in patents. My technical background is in chemistry, so I work a lot with pharmaceutical companies, life sciences, industrial chemistry, really getting to the nuts and bolts of the technical sides of the IP of those kind of companies, and drafting and filing patent application in the UK, and then orchestrating those applications from the UK into Europe and globally. So any questions regarding registering your IP, then I can answer those. So I'll hand over to Ben at this point.
And Ben, just before we get to Ben, just to explain. So Ben Miller, he'll talk about himself, but Ben and I, we are members of the same international organisation, DK. So that's how Ben and I know each other very well. And we spend way too much time together around the world, not just drinking beer, but also helping our clients with international.
And thanks so much, Tom. I think that's a great handoff. So I am Ben Miller. I'm a partner with Bennett Thrasher. We are headquartered in Atlanta, Georgia. We're about 500 professionals. We also have 2 other offices in the U.S. One is in Texas and one is in Colorado towards the West Coast. Our firm does all things public accounting, and we also have a meaningful consulting and advisory arm of our firm as well. I work in the consulting and advisory arm for the most part. And one of the wonderful things about being part of DFK International and being able to get to know Tom and some other folks around the world over the years is that we do get together typically a few times a year, and we're able to really sit down, roll up our sleeves, and work on client matters together, be creative with each other in one place. And we get to really wonderful answers at that global level. I'm excited to be here today. Thanks for including me.
And thank you, Ben, for joining all the way from California. It's very kind of you this hour. The agenda for today, quick run through on the background of intellectual property, what to consider with your strategy, what is a royalty, how does it work, timing, when to really get involved in intellectual property discussions, what is a patent, I'm not sure, I'm never sure quite how to pronounce that, and how that can help your business, how we can support you, the kinds of things to think about when expanding and growing your business, and using IP as the bedrock as part of that, and the benefits of IP specifically generated in the US. I think that's where we're going to end before we get to a little Q&A. First and foremost, David, Esmé, over to you guys.
That's great. I've always gone on the basis that the patent is the level that goes into shoes, but there are definitely people more fashionable than me who'll probably correct me on that. So that's just my working hypothesis. Just thought we'd give you a quick overview about the extent of intellectual property, because one thing we do talk about quite a lot when we're working in this space is what types of intellectual property are most suitable for you. Probably be talking more about patents and other registered intellectual property here, but we just wanted to flag for you the sort of things that's worth looking out for in your business, and also you will have to deal with these other intellectual property rights while you're managing the portfolio. So intellectual property is fundamentally a movable asset. It is intended to represent a fixed form or a crystallized form of an innovation development. Each intellectual property right has its own specific purpose. I'll very briefly go over those in a second, but they're intended to satisfy some form of intellectual or innovative contribution initially to society, very much in relation to contribution to this. It's commercial. So when we talk about registered intellectual property, we are talking about rights which are registered with specific, usually intellectual property offices, which are normally government organizations in territories. When we talk about those rights, normally they operate on a single territory basis. So you will need to register in all territories you care about, and Esmé will come on to that a bit later, because that can be a very important thing to do. Unregistered intellectual property rights are things you might have heard of, but the way that they come into force and the way that you prove that they exist is slightly different, because the majority of the time they're not on a register, don't have a particular number related to that thing. Somebody can't Google it, find the registry that it's at and look at it. So when we talk about unregistered intellectual property, we're talking about things like confidential information, we're talking about know-how, we're talking about copyright, and then in some circumstances, we're talking about things like designs, unregistered designs, because you can register type as well. These cover things like new fashionable clothes, different forms of speaker presentations, speaker providers are available, but the aesthetic appearance of speakers may be protected by design rights. So to break it down, patents, as we're going to focus on, are very much about the technical invention, how something works, something that's special, a new drug, a new therapeutic way of using a battery as a drivetrain, these types of things. A design, both registered and unregistered, is about the aesthetic of a particular product or item. So we're talking fashion, we're talking manufacturing, we're talking about an alloy wheel on a car. Trademarks are an indicator of origin, is what they're intended to be. So it is the logo on your purpose behind it is an identifiable brand, ties into a particular origin. So it's a company that sells these type of shirts. It's a company that sells this type of drink. It's an identification. Confidential information is things you keep away from society, so you put it into the public. So that's a very different type of others. Obviously, it's just on that basis because you wouldn't want to tell them all what it is. And then you've also got copyright, which is things like creative, artistic, music, even things like this is football scores, one famous ones. So there's a lot of confidential information involved in many businesses, and even though you don't see it on a register, part of the value there. So I'll just let Esmé speak about patents and how that interacts with confidential information and trade secrets, which is something we'll touch on later.
Thanks, Dave. Yeah, there's a really interesting interplay between patents, trade secrets, and confidential information. And something that people quite often forget, well, perhaps they just don't even know, is that once you file your patent application, it actually still remains secret for 18 months. So even a filed patent application during that period could be considered a trade secret or confidential information until it's published. And that's a really important thing to think about when you come to your timings. And again, this is something we'll talk more about later in the webinar, for when that information is going to be published. And obviously you have control of that because you have control of when you're going to file your patent application, and then you know exactly when it's going to publish 18 months later. So that can also mean that actually, if you're potentially on the fence about whether to protect some of your IP as a trade secret or as a patent, you could file our patent application, get your flag in the sand, but actually a year down the line or so, you think, actually, you know what? We think it would be better for the business to keep it as a trade secret. You can withdraw your patent application and it's never going to publish. So you can still change track in those 18 months. And again, thinking about the timing, which we'll touch more on later, that's why it's really important with your IP to always be reevaluating it and considering it, and not just doing something, putting it in a drawer and forgetting about it until you launch your product 3 years down the line, etc. The other quite interesting interplay around patents and trade secrets and confidential information is that you could still be protecting something almost via both. So patents are particularly good for being able to slightly extrapolate. So if you've invented a particular concept, for example, some kind of method where you need these core components to make this particular product. You could patent a method making this component comprising A, B, and C, but you don't necessarily need to put in there the very specific, the very optimized formulation. So say you have 20% of A, 20% of B, and then 60% of C is the very best combination of those components. You actually might want to hold that information back as a trade secret, because then other people aren't necessarily going to get right on your formulation for when your patent expires in 20 years. So there's a lot of interplay between patents and trade secret, and especially because the laws with trade secrets have got stronger in the last few years, particularly in the UK, in that they're a lot more enforceable these days, and you just have to take some certain protocols in-house of making sure you have it very well documented, keeping it a secret, the password protected, encrypted, and making sure that only a minimal people in your business or company know the trade secret and have access to it. I think Dave was going to touch a bit more on the brands and business reputation side of things.
Yeah, so just to finish this off, so you've got your intellectual property, as I've said at the outset, it's a movable asset. One common way you will see of people making the most of their particular asset is outside franchising or by licensing a particular brand. It's quite a common way of globally expanding. So if you have a particular product that operates under a particular trademark, you may not be the best person to operate in a territory on the other side of the world. What you may want to do is grant that person a license in relation to your brand. You may set up a supply agreement with them. They may manufacture over there. So this is something where you do get transactions in relation to IP as part of your overall business. Brands are very important, but so is your business reputation. One thing that's often forgotten in transactions involved brands, trademarks, packaging, is you need to be careful as to where the reputation and any goodwill that arises from those sales goes as well. It's always worth having comprehensive dealing with not just tax, payments, pricing, these types of things. But you also need to think practically about how your business is going to be managed and how that IP and asset is going to be managed as part of those transactions. Which leads me on to my final point, really. This is going to come into some of the tax side of things as well. And from an IP perspective, you need to think very carefully about who is benefiting when these particular products, services, goods, brands are otherwise being commercialized. And it's important for enforcement purposes. You want the person who is making the money from that particular good, service, brand, or otherwise to be able to enforce their rights. You need to make sure that they've got protection in the right territories, and therefore you need to make sure the right assets are in the hand of people. So manage your intellectual property very carefully and manage it very carefully.
So I'm just going to, just on the timings point that I touched on before, I'm just going to very quickly run through the process of filing a patent application. Out of all the IP rights that Dave mentioned earlier, filing and actually getting a patent granted is by far the most complicated process out of all the IP rights, and is also naturally the most expensive. So it's quite a long document typically, especially for my expertise for chemistry. You have to include all of the synthetic information. You need to have a full disclosure of how you make the invention, how it works, how someone would put that into practice. You draft and file that. Typically, as UK attorneys, we will file at the UK IPO, but this is just as a flag in the sand. That very first application is just according your date. It's not only getting you protection in GB. Because what we do then is a year later, we file what is known as the PCT, international application, and you do what's called claiming priority back to your GB application, so that then you're basically got another flag in the sand, but it's like a holding period. You then have another 18 months after filing your international application to decide which countries that you want to file in around the world. So this is why it's really important when you think about the timings aspects of your intellectual property in association with your overall IP strategy and the rest of your business planning and your business modeling and your other commercial decisions. Because you do have 2.5 years once you've filed your patent application to decide which countries you ultimately want to go into. So that's the 31-month mark on this timeline. And so it gives you that nice bit of runway to talk to your tax advisors, your commercial team, your marketing team, decide actually when is our launch going to be? Which market are we going to go into? So that you can make sure that when you get to that 2.5 year point with your patent, you are informed and filing in the countries that maps and aligns with your commercial and marketing strategies and tax strategies. The other key point with that is the first 2.5 years of your patent application's life is relatively cheap in the grand scheme of things. Once you hit that 2.5 year point where you're filing in each of the individual countries, it gets pretty expensive. So it also gives you time to plan and think about budgets and make sure you have in your budget a proper IP section ring-fenced off, because once you're past that 2.5 year point, you can't then go back. So it's like 3 years down the line, you can't then suddenly change your mind and say, oh God, we forgot to file in Australia. We really wish we did. That's it. 2.5 years, 31 months, you need to be filing then. So you need to be ready. You need to have your plan. Once you get to that point, your application undergoes what's called an examination procedure. This is why I say the patents is definitely the most difficult and the most complicated process. An examiner will examine your application. They will cite published documents published prior to the filing of your application, and they'll raise objections saying perhaps your claims are novel or inventive, and you'll have to make amendments. You'll have to argue with the examiner. And this, you could have multiple rounds of arguing with the examiner. This could take, as you see on the timeline, another couple of years until you get that patent granted. So again, you can do things to accelerate this. You might want to purposely slow it down because you want to delay those costs. But these are all the kind of things that you also need to think about in line with tax, etc. And obviously, Tom and Ben will talk more about that because there are obviously provisions that you might need your patent granted to be able to latch onto those. Yeah, I think that's enough about the timeline. I don't want to talk too much on it, and I think they're all the key points.
But I just take just some considerations on sectors as well. So we've touched on it briefly already. So when you're looking at your intellectual property, how you choose to protect it, we like to consider a mosaic of rights. It's a bit of a triad term, but one right on its own tends not. So you need to think about what's the best way of protecting business activity from the first point that I started using. The things that Esme's talked about in terms of the patenting side. Patenting is obviously a long process. You need to bear in mind as well that in some sectors, particularly for regulatory reasons, you have a very long time between the actual conception of the idea and the delivery of that product onto the market. I mean, particularly in pharmaceuticals, you may also be looking at certain medical devices, certain other products which are regulated for other reasons, whether they're potentially regulated.
Wednesday, June 26th.
Sorry.
The time is set.
So bearing in mind that the way that your business works and your timelines to market, you need to think about planning your intellectual property strategies. The good thing about things like designs, trademarks, they tend to be registerable and on the register within a matter of months rather than years. So it may well be starting to establish this, you'll actually prioritize trademarks, designs, even though those only cover aspects of the product, potentially not the inventive parts that sit underneath it. You may want to think about your strategy out early and making sure it's right for yourself, such as trademarks, domain names. Give yourself the vehicle to actually provide those goods and services in advance of products as being ready. The other thing that is really important to pick up on here is regulation. And I'll just touch on one point on that, which is the interplay between trade secrets, confidential information, patents that has been talked about. One of the things we always advise our clients on is if you are subject to a regulatory regime, you need to be very aware of the disclosure requirements that go along with that regulatory regime. It may well be if you are looking at the market where there are a lot of regulated devices, you have to go through approvals. There may be some provisions of confidentiality in relation to some of the information you may provide, but fundamentally you are going to need to disclose innovative aspects of your system so that it can be trusted from a public perspective. Then you need to take that into account when planning your strategy in advance, because confidentiality will not subsist in sitting on the FDA's website, because it's and once that is broken, it's broken. That blast is shut on the board, can't bounce it. So make sure you plan that in and make the stall the exact property objection get. And as Esmé says, some of it's a matter of timing. You may choose to file a patent before you need to disclose, because that's a possible term. But you do just need to bear in mind that these rights can be fragile and you need some routes and potential potholes that you'll find on the way down. In terms of cost and revenue, as you can anticipate, there are certain businesses where the intellectual property rights are not that expensive. The product is not necessarily that expensive. Once you've conceived it, you may be looking at revenue generating this very early. Others may well need a lot of investment, a lot of input cost before you start to see any revenue at all. And obviously that's an implications on your business plan. It also should have some very serious implications on your financial plan. The advice should be aware of what your revenue streams going to look like, and likewise investors go on to that as well. Anything you want to add to that, Esmé?
I think just one other final thing to flag is that actually if you're in the field where something's going to get to market very quickly, then sometimes utilising a fast-tracked patent application, as I hinted at earlier, can be very handy just to go alongside with that market launch.
Okay. We're going to go for the really boring stuff now, which is the policies and decisions. Business. This is really a massive hygiene factor, but it is where a lot of businesses get tripped up. We advise a lot of SMEs, large companies, spin-outs, companies of every size on how they manage their IP portfolio, the things they need to do. One of the most important things to bear in mind is that if you have registered intellectual property rights, the authority who is registering that for you will actually do a lot of the legwork in terms of providing the proof that you own those rights, how long they've been in use for, setting up the scope of those rights, so they do in some ways make your life easier in terms of proving that those exist. Particularly when people are coming up for investment or sale, or people are starting to look into business for due diligence purposes. Where people get tripped up is particularly on registered rights. We see this a lot with software businesses, we see it a lot with creative businesses, because realistically, the whole point of having a right is having a monopoly that you can enforce and you can hold market space using it. If you can't prove that you own the rights that you say you have, and you can't demonstrate that you were the first person to create them, for example, in relation to copyright, you're going to have a problem enforcing those. So the real dry hygiene stuff is very, very important in relation to certain unregistered intellectual property rights. Same goes with confidential information. This is not just an offensive thing, it can also be a defensive point as well. Because if you started doing something behind the scenes and somebody comes along 5 years later and tries to patent that particular invention, your records demonstrated that you were doing it before that person sought patent protection are going to be critical in allowing you to hopefully carry on your business or have some leverage in negotiations to allow you to carry on doing it. So it has a varied benefit. There's a number of sides to that particular coin, but you want to make sure that you get all of that right. And if you start the release stage, right policies in place, you put the right practices in place, you know where your records are, what you're doing with the employees, your consultants signing your IPO to make sure you own it. Those types of things are going to be critical. And you'll build in some of these factors in relation to innovation capture, but you want to keep all of these things in review. The situation you're in when there's 4 of you in the start, you're all doing everything together, everyone knows what's going on, that can be an easier scenario. As you get up to enterprise stage, you get bigger, you want to make sure you've got the policies and decision makers in play to make sure that you actively incent IP rights.
I think just one final thing to stress on that from me is just the second bullet point, as I did allude to earlier in the presentation, is just your IP strategy will be constantly moving. You've seen the kind of timelines, especially with the patents, and you always need to be reassessing that and developing that and making sure it's still aligned with the updated commercial and marketing strategies, as you would always update those.
So as we move on to what to consider with your strategy, we've identified 5 areas that we'll just touch on as we go through. First, identify the IP. What is it? Where is it? And who, if anyone, is adding to it? From a tax perspective, it's rather important to establish where the IP actually rests. And that's because it's where ultimately it will be taxed. It's not just where we put the legal wrap around the outside of it. It's where the controlling mind might be. So, the person or persons who's actually creating the thing that generates the potential revenue return going forward. And that's become increasingly more challenging as the world has changed. So back in the good old days with factories creating stuff and everyone living in the country in which they were born in, pretty much, it was fairly easy to identify where stuff came from. And it's not true anymore. Many businesses have got not just employees, but people who who own those businesses scattered across the planet. And so trying to establish who's the brains behind the operation and therefore where the intellectual property rests is quite challenging. Once you've identified that, then the right thing to do is try and protect it. And I'm sure David and Esmé will talk about the legal side of it. But from a tax perspective, we need to understand that bit so we can work out a couple of things. The first is, what tax benefits can we get from the creation of the IP? What R&D reliefs might exist in that jurisdiction or jurisdictions, and how can we access them? And separately, how do we tax both the inward payments and then the outward payments? Because if you're in a group structure, you're not only receiving income from customers and maybe other group companies, but you're also maybe paying away for the use of intellectual property that might exist elsewhere in your group structure, which triggers things like withholding taxes, which we'll come on and talk about in a little bit. So identification is absolutely key to the tax outcome. I don't know if, Ben, you've got anything you want to add?
Yeah. So, I think identification of the IP is super important. Thanks, Tom. The other thing is identification of potential customers, right? And the ongoing reevaluation of what the potential markets are, what the profit potential is in those various markets, and then being really focused on understanding how to price the various, whatever you're selling, let's call it, how to price it in those markets, and then what underlying charges for intellectual property might be. It might be, that you're able to sell to the entire world from one place. It might be that you need to have a more decentralized operating model. But I think what's most important is about understanding who the potential customers are, how you want to charge them for your end product that does incorporate intellectual property, and then to reassess it quite often. Intellectual property is something also, David, as you mentioned, you're constantly having to document what is it? How is it changing? But a lot of those things, as they happen, there's a market side to them too, and people are thinking about how to sell. And so by thinking about the end result and how to price things in the end, when you're first sort of developing this intellectual property, protecting it, putting the legal wrapper around it, but also deciding which taxing authorities will get to touch it, it all goes together. And it may sound a bit overwhelming. It is a lot. And that's where I think groups like us are able to help ask the questions to make sure the business people can continue to focus on their business, but they're answering the questions and taking action at the right time.
What? David, that's me.
Yeah, I think just about the legal side of that, I think Ben's, your points, Tom, are absolutely right. I think, one thing we do consider, one of the times we do come together to provide advice is basically where the IP will be held. When you're creating it, you're starting to look at the network of intellectual property. I think, as Ben said, where you're exploiting it, I think customers and sales are very important. I think, as Esmé has alluded to, you also need to think very carefully about the broader picture for your business. When we talk about exploitation or the use of intellectual property from a legal perspective, you're not just talking about the actual sales to consumers, imports, exports, manufacture. You need to look at your whole supply chain, and you need to think about intervening parties in the middle of that. You need to look at intellectual property as a sword and a shield in this respect. You need to look at the offensive to defensive benefit of having it, preventing others from encroaching on your market. So when we look at territory selection, it is of course where you're going to sell to, how big are your markets, how many you expect to buy. Those are also going to be a priority market. You also need to think about intellectual competitors, where else it has the capacity for manufacture, where else has the capacity to affect re-engineer your technology and start placing it on market. Think about import and export routes as well. Do you need to cover the whole of Europe to try and make sure there's no grey imports of your particular product or service between respective nations that's been sold in a particular part of the EU? There are a lot of complexities to think about. So take a step back, the macro view of your business. Don't just look at exactly where your customers are, but look at the big picture of how you're operating in all the different territories. And on top of that, as Ben and Tom both mentioned, where are you going to hold that? Where's the flow of income going to? Then you need to do that efficiently from a tax point of view, but you also need to make sure all the legal agreements dealing with the transactions of your intellectual property within your business match up to that as well. So make sure that's all tidy as you go through. Okay. So I think this is an interesting one for us. A royalty, just from a legal point of view, we would just categorize that as a payment in relation to intellectual property. It's a word that's bandied around, but it's a very flexible term. People use it in relation to fixed sums, they use it in relation to percentages, they use it in relation to percentage of gross revenue, percentage of net revenue, but we use it with a capital R, pretty much define it as however we want, but I can anticipate that's quite different in other sectors as well. So interested in terms of how that's looked at from a tax and transfer perspective.
Indeed. And it won't surprise anyone to learn that in the tax world, we're trying to find things as wide as possible so we can tax them. So I'll let Ben speak to the transfer pricing point, and tax sort of follows from one and then leads back to driving the transfer pricing and back and forth as we go until we find the most economically sensible outcome that we can within a particular structure. Unfortunately, to steal some of Ben's thunder, we can't treaty shop any longer. What that means is between two different countries that might be sharing information or transferring or selling stuff between them, we can't just say we'd like to use the Channel Islands as our place in which we want to hold our intellectual property and pay our royalties to, because the Channel Islands doesn't tax them. Because unless we have stuff there, it's substance, as they call it in the Channel Islands, that isn't going to work. So we need to be mindful not just of the tax regimes around the world and interaction between them, but also what is actually feasible within inside the confines of substance, OECD regulations and all that good stuff. So why does it matter? Well, most countries around the world will tax the receipt of royalties. So if a company in the UK has an intellectual property right and licensed out that IP to another, usually a grouped company, connected party somewhere else in the world, then when it receives its royalty, it will pay tax on it to the extent it has a profit at all. But the country paying the royalty may have to withhold tax on the payment of the royalty when it pays it to the UK. And that is largely to protect the tax base of the country that is paying the royalty. Right? So if you think about it, what they're really saying is saying, well, you UK company, are benefiting from my customer base that exists in, let's say, Germany. And the German Chancellor says, well, I would like you therefore to pay tax here. But there's no way they can do that. They can't force me as a UK company to become tax resident in Germany. They can try, but they won't be able to do that. So instead what they say is that, well, we're going to tax you as if you were here anyway. So we're going to tax the royalty and say, look, you made that in our country, so we're going to have the cash, thanks. So they will apply a tax rate to the royalty. Let's say it's 20%. But the UK and German tax authorities would have sat down together and said, well, actually, that doesn't really seem commercially sensible. We want to do business together. We don't, let's stop with all this protectionism. So they will agree a reduced rate. And they'll say, okay, well, that reduced rate is 5%. So yes, there's a little bit of a giveaway to the German authorities, but that's better than 20%. And yes, we're going to tax it in the UK, but we get credit for whatever we pay in Germany. So withholding taxes are really important. This is the treaty shopping point. So wouldn't it be nice if we had no withholding taxes? Now, it's possible in group structures to structure them in such a way that if you have the right substance in the right place, then you can swing the royalties around in order to reduce the damage that withholding taxes can generate. That's particularly important if the end person who ends up receiving the royalty doesn't make profit. And the reason those companies don't profit is because they're the ones that got all the burn on the design and creation of the IP in the first place. They're typically the ones with the high employment costs. And so they don't tend to make large profits. And if you don't make large profits or any profit at all, you've got a tax liability, you've got no tax liability, you've got nothing to offset the withholding taxes you've already suffered elsewhere in the world. And so it's just lost money. It's a little bit like if you want a VAT, well, it's a little bit like when you've got irrecoverable VAT, because you can't, get it back because you don't have a supply to match it against. It's a horrible thing. I think about VAT. Ben's on the call. Ben's an American. Ben doesn't know what VAT is. And if anybody's American, I do apologize. But for those that live in Europe and elsewhere in the world that have similar things, we'll know what I'm talking about, perhaps. So that's how double tax treaties work. Now, why wouldn't the UK company have a liability to tax in the first place? Because of all of its cash burn on developing the IP. Well, there's two things, really. One is research and development credits. They exist. Please ignore all the negative press. They are still incredibly valuable reliefs. We are not the only country in the world that has an R&D system. The Americans have one. The Canadians have one. The French have one. The Germans have one. Go on.
Yeah, I think that's another one of the layers that has to be evaluated as you look
I agree
through
too.
where you put your team and where you want to situate your IP legally from an economic or tax perspective and everything. But yeah, those can be huge benefits for a company.
Massive benefit. You're absolutely right, Ben. And I think really importantly with R&D, and I know the Americans do the same thing we do, we mess around with it every couple of years to make it less or more attractive, depending on which colour tie the government's wearing that week.
That's right.
So, yeah, so it is really, really important. It can be quite challenging to move your people around, but sometimes you can move the claim from one country to another country. Sometimes you can use both, but it is something very, very key. Ours allows you to get a tax credit back from the UK government, so you can get cash back, actual cash. If you didn't know that, you should be a claimant. You definitely need to look at that. I'm not sure we're alone with that, but it is certainly a benefit of the UK system. And one of the other things is how you tax the income you generate from your IP at the end of it. We in the UK have a patent box.
Patent box.
We're a patent box. All right. Okay. I will remember, I promise, one day. It's only been 20 years. I'll get there eventually. So with the patent box, we in the UK have one of these in its simplistic form. It charges tax. Any revenue you generate, any profit you generate from exploiting your patent here in the UK to the tax of 10%. So which is significantly less than 25, which is the usual rate of tax. To get that benefit, you have to jump through some hurdles, one of which you have to have a patent. So you have to work with Esmé and her team in order to achieve that and go through that. But once you've got it, you still haven't completely cleared those hurdles. You have to then work out what that profit is. So of course, often what you have is a product which includes the patented bit, maybe multiple patented bits, but other bits as well. So what is generating the revenue? Can you identify it? Can you actually model and work out what the revenue return is on that particular thing? Once you have, you pay the lower rate of tax, and definitely worth going after if your revenues are significant. So that's royalties in a nutshell. That's how they work, broadly speaking, for tax purposes. So when do you do all of this? Right? I mean, I think we've sort of alluded to that this is quite a tricky process sometimes, and it can feel a bit overwhelming. I think it was the word that Ben used. We don't want it to feel that way because it's obviously something that we don't want to stop people doing these businesses. Timing wise, how do we structure this? How do we sort of build it? So we've got 7 steps here. They don't always going this way, but this is broadly speaking the way we think it should go. So perhaps maybe David, Esmé, you can start off on step 1.
Yep, absolutely. So this is relevant to a lot of businesses, particularly IP heavy businesses. You will find at the early stage, particularly, now your majority of your assets are intellectual. You're looking at know-how, you're looking at the people who are operating the business. They've got maybe some confidential information, but you're really looking at businesses at early stages that have the ability to build on a relatively unique idea, concept, or information. When we're talking about investment strategies and IP, some of the policies, some of the practices, you don't necessarily need to have all of your intellectual property that you'll need for the rest of the life cycle business. There are 6 steps in place just yet, but it really helps when we're looking at investment scenarios to understand what investors are going to be looking for. And some of that is just hygiene factors, knowing what might protect your business. Have you thought about getting that protection? Have you thought about which territories you're going to get that protection in? All of these things are really important. Look into the businesses that through the whole range, actually, Series A, B, C, seed investment. Are they managing their IP in a sensible way? And the extra layer on top is if you are getting to potential revenue generating, have you also thought about the tax? You work with people like Ben and Tom to strategy of that as well. Realistically, some companies will not need any or all of these stages. Some of them will be lucky enough to be revenue generating from the start. And at that point, it's just a sensible use of your money to support your strategy IP. But if you are going through these stages, particularly if you're, for example, a pharmaceutical targeting business, you're looking for an active compound to take to market, you are going to need a huge amount of upfront investment to get through the clinical trials that you will need to satisfy. You will need numerous rounds of investment, most likely to get there. The virtual patient capital, and larger investment here in the UK might assist with that, but you're going to be fundraising on a regular basis. So getting your IP strategy right, getting documented IP strategy, business plan, and portfolio of IP rights right at the outset is critical. And just building on that, as May said, to satisfy Series B, C, and D. If you've got a global strategy for your business, you should also have a global IP strategy to support that. And that's what we expect
I completely agree. And just to sort of throw in that from an investment strategy perspective, there are tax incentivized schemes out there. In the UK, it's SEIS and EI has been the most common, but there are others, venture capitalist schemes. The US and other countries around the world have very, very similar schemes to try and incentivize not only inward investment, but also the growth of the company itself and how it uses that money. They do change from time to time, but they are phenomenally attractive, usually for the investor coming in to those schemes. So definitely on those things. Ben, is there anything any particular step that you want to sort of zero in on? Have any comments on?
Yeah, I mean, for me, I'm often focused on the exit, right? So here, that would be the sale of the IP. And what is the end game and end goal, right? And that should really be something that drives how all the steps, 1, 2, 3, 4, 5 are going, so that when you arrive at 6, you're able to have the end transaction that you're looking for, right? So do you want the IP to be one, sort of bundle of IP? Do you want to make sure what IP are you going to be selling? A piece of it? Do you want to sell rights in a different jurisdiction versus the jurisdiction that you're, if you make a novel compound and it's going really well, perhaps you want to continue to exploit that in the UK, maybe in Europe or Ireland, but maybe you don't want to have to figure out how to do the trials and to get it also approved in Asian markets, and you want to sell IP for that indication. And so it's something really just to be mindful about. To me, this is very much the first comment I had almost, right? Think about where you're going to be selling this and continue to think about it. Otherwise, it could be more of a science project than a business endeavor. And that, as much as it does help make the world go around, we love for our clients to also feel successful financially. And sometimes we have come across some different things, right, that can come up and complicate things. I don't know if we want to go on to the next slide, Tom. Maybe there's a few different examples of items that we do often see, right? And so with that, the first and one of the ones that's toughest to deal with after it's already occurred is IP across multiple jurisdictions. So to the extent your R&D teams are in different places, or the brains behind the operation lives in 3 places during the year, every year. I mean, they like different seasons in different places. It's lovely here in the Mountain West in the United States right now. It is not great in other parts, right? So people like to move around, and that's something we're seeing more and more. I'd imagine that that's even more pronounced in the UK, possibly, than in the US.
And let's be honest, France, Italy, they have slightly better environments, nicer weather, better food, better wine than we do here in the UK. We just have a brutally oppressive, humid weather, which we call muggy because we're British. But so we do move around quite a bit. And when we do that, we can create huge problems, not from a tax perspective. Now, these are not insurmountable challenges, but it's something you must be aware of if you're in business. People do move around more often than they once did. It can move not just the IP, it can move the companies themselves for tax purposes. So just bear that in mind. It's not to stop you doing anything. It's just if you know about it in advance, then you can plan your strategy around it to make sure that you benefit from it if you can. And if you can't benefit from it, stop yourself from being caught out. A lot of what we do is just ensure that our clients maximize what they're trying to achieve, not just with their business, but also with their life, because one shouldn't protect against the other.
Just to very quickly add, there's also legal ramifications on that. For example, if an invention has been made in the US, there's actually a legal obligation for that to be filed in the US first, or you get what's called a foreign filing license. And there's a few other countries across the world that have a similar legal requirement. So again, that's another reason why it's really important to have those conversations with all of us at those early stages to make sure it's all done appropriately from day one.
You make an excellent point. And I think one of the things I've seen many times is that when you come to the end of the set steps and you're selling something, the buyers will carry out due diligence. And things like what Esmé just mentioned, are things being done correctly along the journey are really important to have done. And if you haven't, sometimes we can work our way through it, but sometimes it just changes the price. And so it's working with your team to understand what you need to do around the world. And when you need to do that is really helpful. But I think the other thing, the working from anywhere IP is, I know on my contract, a large part of it is talking about the protection of intellectual property to the extent I create any. And it ensures that the IP rests in the hands of my employer. And that's something we're seeing more and more around the world with our people. So looking at just simple things like employment contracts, ensure that to the extent that you can, you protect. Without David or Esmé as the lawyers on the call, you've got anything to say to that?
Yeah, I think it's a really interesting one, and it basically goes down to presumptions. The nice thing about intellectual property is that a lot of it is kind of harmonized across the globe. There are deliberate treaties in place to cover that, and it's quite nice. There's a lot of countries think the same way. But by way of example, there's professor's privilege in Sweden. So whereas the normal situation for most employment scenarios, you would expect something that was created during the course of research and development as part of the professor's role would go to the university. In Sweden, that's not necessarily the case. So we have experts in Sweden who sort of look into this quite a lot. But you need to bear in mind that that can be true for creation of copyright. There's a lot of international treaties covering that. And normally these rights arise immediately on creation. You need to be very careful about who owns that. You can put certain things in contract, but sometimes you will have legislation in territories that will override those provisions. So being aligned to that, and if somebody's going and saying, well, I'm going to work in Bali in the 6 months, I mean, great for them, no doubt. But think about the tax implications, think about the IP ownership, and ensure that if somebody's, for example, resident in Bali on a temporary visa, does that have any impact on what they create and who can own it?
Excellent point. We've got a few questions that have come in, and I like questions. The first one here is from, I'm not going to say their name on the thing. And they've asked, from an artistic perspective, is a body of artistic work one entity for IP protection, or does each individual piece of work of music need separate patents? And I think, just to add a little flavour to this, I was watching John Oliver last week tonight, the other evening. I love John Oliver. He doesn't need me to pitch his show, but I shall. But he was talking about AI and AI, all the noise that we see online and how that gets created and where they get their information from to be able to generate the songs and everything else from. So perhaps maybe David, Esmé, I don't know if Ben's got a view on how you protect that IP. Can it be protected?
It's a fascinating one. The way that copyright works is that it's got a lot of subcategories in terms of different types of works that can be protected. So, for the purpose of the question, let's assume that you are putting together one large graphic montage. And normally it would be defined as a piece of cohesive work in a way that you would define it. So if you create a 3-canvas piece of art and you present it as a single piece of artwork, then you would say, well, copyright has arisen in this entire piece. The main thing to consider is then how that is infringed. So somebody can infringe your copyright by copying all or a substantial part of that work. So if they were to say one of the 3 elements, you would argue that's a substantial part of the work and still should be something that you enforce in respect of. So as said, Britain about copyright in the majority of territories is there's no registration required. The US has an ability to register copyright works. China also has a register for copyright works, which can be really useful for takedowns. Basically, these will arise automatically. So when you're looking at the artistic, that's how it generally work. Esmé already mentioned briefly how inventions work for patents.
Yeah, on patents. So it's all about the technical innovation underlying it. So if there's some kind of system behind that that's helped create it, depending on what that technical output is, it could be patentable. But in the UK, there's quite strict laws on what is a technical effect. And it's an interesting area because it's still evolving. So there's quite a lot of patent decisions coming down as to what is and what isn't and where that technical effect line is. A lot of the examples that are coming through are things like, in a car, the computer related system has increased the speed or the efficiency of brakes. So obviously has a very clear technical effect of it makes the car stop quicker and things like that. So that's quite a nice example of how AI related things can still get patents, but it's a tricky fine line.
If they can create a piece of AI that turns off all the bings and bongs in European cars now, I would buy that tomorrow. So, sorry, Ben, that's a very EU thing. But
Well, I was going to sort of actually, as we were talking earlier, I was thinking about AI and machine learning, right? And so it's not, when you say work from anywhere, it's not only where the people are sitting, it can also be where things are processed, right? And where servers sit and where algorithms rebuild themselves. And that is something that you need to be mindful of as you do. If this is a bit aside from the music situation, but it's something that you really need to be mindful about. And more businesses are using these things. We use AI in our business at Bennett Thrasher quite commonly, and we have to be very intentional about how we do it, about how we incorporate it into our work so that our rights stay intact. Actually, I think
that's a really interesting look. We're moving into a different area here, but But I hope whoever asked that question, I don't want to name names, that helps them a little bit. So copyright is what you're looking for, is I think part of the answer. And we've only got a couple of minutes left, and there's the normal question that comes from someone, but thank you for raising it, which is, if there's one thing that you would say that any group of companies that is, when they're talking and thinking about IP, should do, what is the one thing they should do first? What's the thing that people forget to do most commonly?
Licensing. So that's the one that's really interesting. We work with a number of businesses, and the assumption is, because I own this IP, I can do what I want with it. And that is fundamentally true. But going back to the original point, is what you can prove. So actually, if you're talking about, okay, this person created this IP, we get the rights to use it, and it's all hunky-dory. If everyone's friendly, everyone's under the same system of control, everyone's going in the same parts of the business. But if you look to sort of hive certain parts of the business out, you end up selling a business unit, suddenly you're in a position where you're like, oh, actually, who holds these rights? Who's got licenses? Who's got permission to use it? And one of the first things forget to do is put something in place within the business, regularizes all of those rights back and forth. Then, again, that becomes a basis for financial as well as just practical IP steps. But get your intra-group licensing right, because actually that's the framework from which you can then expand, change, and work, as long as you've got control of the size. If you don't, putting that back in place with a third party, you don't actually deal with that often. It's much more complicated and unfortunately expensive.
Ben?
I think,
Go ahead.
sorry, I'll make mine quick. Something people forget to do, and it seems really stupid, but is actually just come to an advisor early enough. People wait far too long and think, oh, I don't need to deal with that yet. But as we've alluded to, that's way too late. Once you've made public disclosures, you're shooting yourself in the foot with a patent. So even you might actually not be ready to file on anything once you've spoken to your advisor, but it's better to have that plan in place as to when you will, rather than do it the other way around and be far too late.
Piggybacking that, there are exemptions and different things in the UK for smaller companies from a tax or really a transfer pricing perspective. And the thing I've run into the most is the companies will say, well, now we're a large company, so we'll deal with it. But as we've been discussing from the very beginning of this green sky idea or whatever the new innovation is, everything matters for the exit. You can't wait till you feel success to start thinking about the exit. It has to happen at the beginning. Treat it like part of the investment in the technology.
Do you know, that's a great way of putting it, Ben? Mine's very similar. Is, don't wait to address, the complexities of your business. I know it's hard, and, we want to just be getting on with doing the stuff that we love, talking to customers, creating our ideas, turning into real things, and, maybe selling them and watching them flourish in the outside world. But the reality is that if we don't get all the other bits working, then it can really bite later on. And that won't just distract you from the thing you love doing. It can actually really cause proper problems for you and your business. So just getting all the fundamentals right as and when you need to get them. And that means talking to your advisor as early as you can, keeping them engaged, buy them a coffee every now and again, and then speak to them and really help them understand. Because we come along the journey with you. It's why we all get involved in this in the first place, right? It's we don't have the ideas ourselves necessarily, but we love watching other people have them and helping them and helping them develop. And we're here. And that's what we're here for. So with that, thank you very much, all of you, for joining us today. I hope you got something out of the chat that we've been through. If you have any questions or you just want to reach out for a chat, then please contact any one of us. We'd be more than happy to help. So thank you very much. And thank you guys for speaking so well today as well.
It's been fun.
Thanks, everyone.
Take care.
Bye.